everybody, welcome back to the next section of going over this contract. We are going to be covering the 1 to 4 family residential contract for resale today, paragraphs 12 through 17. So as usual, let's just jump right into it. So paragraph 12 reads as follows. 12. Settlement and other expenses. A. The following expenses must be paid at or prior to closing. 1. Expenses payable by seller, i.e. seller's expenses, are releases of existing liens, including prepayment penalties and recording fees, release of seller's loan liability, tax statements or certificates, preparation of deed, 1/2 of escrow fee, and the other expenses payable by seller under this contract. And then you have B, seller shall also pay an amount not to exceed, and then there's a dollar amount blank, to be applied in the following order. Buyer's expenses which buyer is prohibited from paying by FHA, VA, Texas Veterans Land Board, or other governmental loan programs, and then to other expenses as allowed by the lender. And then you have section 2, which is expenses payable by buyer's expenses. Appraisal fees, loan application fees, origination charges, credit reports, preparation of loan documents, interest on the notes from date of disbursement to 1 month prior to dates of first monthly payments, recording fees, copies of easements and restrictions, loan title policy with endorsements required by lender, loan-related inspection fees, photos, amortization schedules, 1/2 of escrow fee, all prepaid items, including required premiums for flood and hazard insurance, reserve deposits for insurance, ad valorem taxes, and special governmental assessments, final compliance inspections, courier fee, repair inspections, underwriting fee, wire transfer fee, expenses incident to any loan, private mortgage insurance premium, VA loan funding fee, or FHA mortgage insurance premium, as required by the lender, and other expenses payable by buyer under this contract. And then 12B reads, if any expense exceeds an amount expressly stated in this contract for such expense to be paid by a party, that party may terminate this contract unless the other party agrees to pay such excess. Buyer may not pay charges and fees expressly prohibited by FHA, VA, Texas Veterans Land Board, or other governmental loan program regulations. That was a mouthful. All right, let's go back and go through this. So 12A1A simply states that the seller at closing is going to pay off their loans, pay off any money that they owe related to the property. So this is one of these sections that covers the fact that they're going to be paying any outstanding taxes. If there are any due, any liens that are on the property have to be paid. And basically the buyer is going to get the property free of owing any money or anything else on it. So it's the title company's job to make sure that all that stuff is paid off, all the fees are paid, the deed is done, and all that kind of stuff. So those are seller's expenses. And then we have 12A1B, which is the section where if the seller is going to contribute closing costs to the buyer, this is where you put that amount in. So if you negotiate the seller paying $3,000 in closing costs, you're going to put not to exceed $3,000, and that $3,000 is going to go in the blank on 12A1B. It's important to note, for those of you that are newer, that money that goes towards the buyer's closing costs cannot be applied to the buyer's down payment. So sometimes there's a little confusion on that for folks that are newer to real estate, and so that's not the case. So if, for example, we negotiated $10,000 in seller paid closing costs, and we put $10,000 in here, and the actual closing cost amount was only $8,000, then the buyer actually loses out on that $2,000, and the seller's not going to have to pay it, because that extra $2,000 can't go towards anything else. It can't go towards your down payment. It can't go to do anything. So it can't go to pay commissions for the buyer if the seller's sharing those commissions with the buyer's agent, listing agent. So if your negotiated amount exceeds the actual amount of closing costs, then your buyer just loses out on that. So make sure before you negotiate some huge amount of closing costs for your buyer that you talk to their lender first and figure out what exactly it is they're going to need in the amount of closing costs, so that you don't negotiate a seller paid amount that's way in excess of what they'll need and basically throw away money at that point. There is also a strategy that's out there where perhaps your buyer wants to offer, let's just say, for example, a full price offer, but they also want some help covering their closing costs so that the money doesn't have to come out of pocket. So occasionally you'll see somebody add a a dollar amount here. So let's just say it's $3,000, and then also add $3,000 to the sales price. And so you're basically paying for more than list price, or you're paying for more than you would want to normally, but then you're asking for some money back. So that's a strategy as well. The only thing to be check on that is make sure you're going to go ahead and clear the appraisal once that pops up. Then you have 12A2, which I'm not going to go through again, but that basically lists all the expenses that the buyer could possibly pay. And there's some in there that are pretty standard. There's some that are in there that are not standard, but those are basically all the expenses that the buyer will have to pay, and so they're required to pay as part of closing out the contract. And then 12B simply states that if any of the expenses exceeds an amount expressly stated in the contract, so if there's an amount in the contract that says such and such party will pay this amount and no more, and that amount ends up being more, then that party may terminate the contract unless the other party wants to pick it up. All right, so that is this paragraph 12, settlement and other expenses. The biggest thing to point out here, the two biggest things are what each party is responsible for paying for. And so you can help your clients out by explaining that early on before they actually sign a contract about what they're going to be responsible for paying for. And then 12A1B, which is the section where you're going to put how much seller paid closing costs are going to go towards your buyer's stuff. The next paragraph, moving on, is going to be paragraph 13, prorations, and that reads as follows: taxes for the current year, interest, maintenance fees, assessments, dues, and rents will be prorated through the closing date. The tax proration may be calculated taking into consideration any change in exemptions that will affect the current year's taxes. If taxes for the current year vary from the amount prorated at closing, the party shall adjust the prorations when tax statements for the current year are available. If taxes are not paid at or prior to closing, buyers shall pay taxes for the current year. So not a whole lot to this paragraph, but it simply states that all of these things listed are going to be prorated out. So if you are buying a house dead smack in the middle of the year, you're going to be prorated half, and the other party is going to prorate half. And so if, for example, it's let's say a buyer paid an assessment at the beginning of the year and they paid it for the whole year, and you're buying it halfway through, well, guess what? They may get a credit from you in that amount for whatever's prorated towards them, and that will help balance out their settlement statement and their closing disclosure in the end, so they get credit for that. One thing that I really want to highlight here that some folks don't understand is that the taxes are prorated based on what is known at the time. So either last year's taxes, or maybe they know this year's value, but they don't know the rates yet. So they're going to go ahead and take this year's value and use last year's rates. There may be some discrepancy there, but one important thing to remember is that if the amount given to taxes from one party to the other is not enough when the tax bill actually comes out, it is incumbent upon the parties to work together to rectify that. So for example, the way this usually works is that if you're closing anytime before, let's just say September, October of the year, if you close anytime before that, usually the title company will try to guess how much the taxes are going to be, and then the seller will give a buyer a credit for that amount of taxes. All right. If it's later in the year, by that point they actually have the tax bill, and they'll generally just pay that year's taxes right out of escrow once closing occurs, so nobody has to worry about it. But if your buyer, all right, is getting a credit from the seller for those taxes, then at the end of the year when taxes are due, your buyer is the one that has to pay the taxes for the current year. And so that all kind of balances out. But if your buyer's buying in the earlier part of the year, they just need to be aware that they will be responsible for taxes more than likely. The other thing is that sometimes somebody will have a certain exemption on their property, and by the sale occurring, those exemptions will go away. And so the title company is well within their right to prorate taxes based on values that don't have those exemptions in place. And so just make sure if the title company is saying, well, the taxable amount is $100,000, because we're removing the exemptions, don't go back to them and say, no, dummy, it's $50,000 because look at all these exemptions, because they are probably removing those exemptions because they will no longer apply. All right, so just be careful when you're double checking everybody's numbers that you know what they're calculating on. So that's prorations. Everybody gets to pay their fair share of however much they own the property for that year. Moving on to paragraph 14, casualty loss. It reads as follows: if any part of the property is damaged or destroyed by fire or other casualty after the effective date of this contract, the seller shall restore the property to its previous condition as soon as reasonably possible, but in any event by the closing date. If seller fails to do so due to factors beyond the seller's control, the buyer may A. terminate this contract and the earnest money will be refunded to the buyer, B. extend the time for performance up to 15 days and the closing date will be extended as necessary, or C. accept the property in its damaged condition with an assignment of insurance proceeds if permitted by seller's insurance carrier and receive credit from seller at closing in the amount of the deductible under the insurance policy. Seller's obligations under this paragraph are independent of any other obligations of seller under this contract. All right, so let's go back through this. So if a property, for example, and I've actually had this happen a couple years ago, one of my agents had a property that during the last couple weeks, a quarter of it caught on fire, and a big chunk of it burned. And so then we were stuck with a contract, and we had to figure out what are we supposed to do. And this doesn't happen very often, but it does happen. And so in this case, we had the insurance adjuster come out and assess the damage. We determined that the damage was so extensive that they would not be able to repair it by closing or by closing plus 15 days. They just would not be able to meet those guidelines. And so, we were kind of stuck with a couple different options. In that case, the buyer opted to terminate the contract, wait till repairs were done because the estimate was that they'd probably take a few months. And then if they were still looking and this property came back on the market, they'd be more than happy to do that. So if something happens, the seller has to make it right. If they can make it right by the closing date, great. If they can't, all right, the buyer has these three options. They can terminate and walk away, which I think that most buyers would probably give a seller some extra time to get it done, especially since their option as the buyer is to turn around and go find another house and put it under contract, which would probably take longer than 15 days. And so I think in most cases the buyer wouldn't terminate, but they do have the right to terminate if they can't make the repairs by the closing date. Now, what often would happen is that they could extend up to 15 days, closing date adjusts automatically, to give the seller some more time to go ahead and correct the issues that are a part of the damage from the fire or other casualty loss. And that's okay. Now, the third option, which is that the buyer can accept the property in its damaged condition with an assignment of insurance proceeds, is if the seller's insurance permits it, and then the buyer will get a credit from the seller for the deductible because that's the amount less that they're going to get from the insurance company. This instance will almost never happen if your client is getting a loan. I have never seen nor heard of a lender who was like, oh, part of the property burned down, no big deal, we'll close on it, you just get those insurance proceeds and fix it whenever you get them. I've never seen nor heard a lender say that they would do that. It doesn't happen very often, so this might be a case where maybe it's a cash buyer or some other entity that's not a standard lender. They may allow the sale to proceed and just collect the insurance proceeds. But if you're using a lender or even conventional, definitely government-backed lending, they're not going to let you close on this while this damage is still in place and hasn't been fixed or corrected. So heads up on that. Moving on to paragraph 15, default. So this is a big one because we have heard lots of references throughout the review of this contract to paragraph 15. This is what happens if somebody's in default. All right. So let's read through this and we're going to go back through it. If buyer fails to comply with this contract, buyer will be in default, and seller may A. enforce specific performance, seek such other relief as may be provided by law, or both, or B. terminate this contract and receive the earnest money as liquidated damages, thereby releasing both parties from this contract. If seller fails to comply with this contract, seller may be in default, will be in default, seller will be in default, and buyer may A. enforce specific performance, seek such other relief as may be provided by law, or both, or B. terminate this contract and receive the earnest money, thereby releasing both parties from this contract. All right, so let's go through this. Now, I'm going to tell you right up front that in most cases, the party that's in default just gives up their earnest money and walks away. All right, now Lots of times, parties will want to argue over the earnest money and who gets what, and there may be some negotiations there, but generally that's what happens. But it's not uncommon, though, for somebody to enforce specific performance or seek other relief or sue somebody. That also happens. So you need to be aware, though, both of these sections within this paragraph are pretty much the same, but one applies to the buyer and one applies to the seller. So I'm just going to talk about these in general and just realize whatever side you're on, that's how it works. So they may enforce specific performance, seek such other relief as may be provided by law, or both. So they can sue you for damages. They can sue you to force you to go forward with the purchase. All right, or whatever other relief is provided by law, they can do that. The big board here then is or they can terminate the contract and receive the earnest money as liquidated damages. So there's some confusion here. Now, again, I'm not an attorney, nor are you, and this would be definitely something you would want to refer your client to an attorney for, but you can't enforce specific performance or sue for damages and keep the earnest money. That's not the way that works. You have to pick one. You either have to sue for specific performance or other relief, okay, or both, or you have to take the earnest money and walk away. Part of receiving the earnest money, and almost all title companies will require this, will require you to sign the release of earnest money, which at the very first paragraph of that is the most important one. It's not the who gets what and inside of that form. It's the fact that that form, the very first paragraph, releases everybody in the transaction, the brokers, the title company, the lender, both principals, releases them from liability. So by signing that, you kind of walk away from your ability to sue somebody later on. Now, an attorney might have a different opinion based on your client's specific case. And so again, this is not, we don't want to be out there giving legal advice saying that, if you do this, you can't do that. But if we read the plain language of the contract, you can either sue or seek in specific performance, or terminate and receive the earnest money as liquidated damages, but you may not do both. In addition to that, if the seller is found to be in default, there is no provision inside this contract that would force them to pay for your buyer's inspection or pay for your buyer's appraisal that they got or anything like that. So sometimes you'll hear buyer's agents say, well, we'll take our earnest money back, but we also, your seller is going to have to pay for the inspections and this, that, blah, blah, blah. The reality is there's nowhere in this contract that allows for that. If the seller does it, it's out of the goodness of their heart, unless the buyer wants to turn around and sue the seller for the cost of their inspections and their appraisal, so on and so forth. But in order to do that, that means they can't collect the earnest money until that suit is settled, which most buyers don't want to do. Most buyers want to just move on and go find another house if the seller is the one that's in default. So just be aware of this. Again, if you're venturing into the default paragraph and it's contentious or there's something that's just off about it, it's not flowing smoothly and nobody's really just easily willing to give up the earnest money, go ahead and contact your broker and get some guidance from them. Moving on to paragraph 16 is mediation, and it reads as follows. It is the policy of the state of Texas to encourage resolution of disputes through alternative dispute resolution procedures such as mediation. Any dispute between seller and buyer related to this contract which is not resolved through informal discussion will be submitted to a mutually acceptable mediation service or provider. The parties to the mediation shall bear the mediation costs equally. This paragraph does not preclude a party from seeking equitable relief from a court of competent jurisdiction. So this paragraph really says that the state of Texas wants you to try to do dispute resolution, mediation. All right, it's usually much less costly, and usually you're able to kind of work out some of your differences, but it doesn't preclude somebody from suing the other party should they want to do that. If you are getting into this point where you think you're going to enter mediation, definitely reach out to your broker and get some advice from them on how that's going to work. All right, pretty simple paragraph there. And then finally, paragraph 17, this is the last paragraph for this video, attorney's fees. Reads as follows. A buyer, seller, listing broker, other broker, or escrow agent who prevails in any legal proceeding related to this contract is entitled to recover reasonable attorney's fees and all costs of such proceeding. So this one's important because as you kind of come down the line here for these last three paragraphs, if somebody's in default, they can sue. Before they sue, we'd like them to go through mediation, but if they don't want to, they don't necessarily have to. And then number 17 says that if you lose, all right, you may have to pay for everybody else's legal fees when you sue them. So, this is one of those things that when you go talk to an attorney, the attorney is going to help your client weigh the reality of their situation and how, what their chance of prevailing in a lawsuit is going to be. Because if they lose, then they could also be on the hook for all the attorney's fees for everybody else. All right, and any other costs, professional witnesses, evidence, having things drawn up. I mean, all the different stuff that goes into a lawsuit. So this is just clarifying to everybody that if you sue somebody and you lose, you could have to recover and pay for their attorney's fees and anything else associated with the proceeding. So anyway, quick 21 minutes for these sections. I hope that this was informative. There's a couple of highlights in these. Otherwise, these are just things you need to have some working familiarity with. But if you look at most of this section, with the exception of 12A1B, there's nothing really in this section to fill out or do, but you do need to be aware of each part of this and how it applies to your client's transaction. As always, if you have any questions, post them below and we'll get those answered. In the meantime, thanks for watching, and we'll work on getting the next section of paragraphs out to you guys. Have a good day.